Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. New rules were implemented on the 13th of January that ban most payment surcharges for consumer transactions, including debit, credit and PayPal. Payments not caught by the ban, for example payments using a corporate card, mean traders can only charge their actual additional costs. In two recent cases, the Court of Appeal has restated that the words in business-to-business contracts will generally mean what they say, even where they have bizarre or unintended consequences. The only exceptions are where it's necessary to imply a term for the contract to achieve its purpose, or where the term is so obvious it goes without saying. In one case, Process Components, PC, licensed intellectual property rights to Case and Keck Gardner, KKG. The license agreement required KKG to keep the license confidential. KKG sold its business and disclosed the license agreement in the sale process. PC terminated the license because of the breach of confidentiality. Noting that the terms had stated that breaches of confidentiality would be material breaches, the court agreed with PC and confirmed that the contract was validly terminated. The court refused KKG's argument that there must be an implied term that allowed it to disclose the agreement to a prospective purchaser. In Interactive E-Solutions, IES, the O3B, IES made claims against O3B following a dispute concerning whether O3B had obtained the necessary regulatory approvals. IES's claims included specific performance and compensation, but O3B successfully argued that it was not liable as the contract included a widely drafted clause that excluded any liability except for fraud. We have previously reported on the case of SFO v ENRC that highlighted how difficult it can be to assert privilege. If privilege can be substantiated, then relevant documents do not need to be disclosed to a court. More recent cases have reached similar decisions. Legal advice privilege is only available for legal advice to a law firm's client, not for data capturing exercises or interviews with employees of a client company or other third parties. If legal advice privilege is not available, a party may seek the protection of litigation privilege, but that's only available where there is a real likelihood of litigation. The recent case of the Health and Safety Executive v Duke, however, held that an official investigation being underway was not enough to substantiate that there was a real likelihood of litigation. The importance of explaining why a contract is being terminated was highlighted in the recent case of Phones for You in Administration v EE. In this case, EE's termination letter specifically referred to its right to terminate because of the appointment of an administrator rather than for any breach of contract. EE's subsequent claim of $200 million for loss of bargain resulting from Phone for You's repudiatory breach was dismissed by the court because it had not been identified as a reason for termination. The government has now responded to the Taylor Review that was published last year. As you may recall, the review concentrated on the so-called gig economy of part-time and flexible workers. The response has mainly been to commit to enforcing existing law and to crack down on the use of unpaid interns, name and shame employers that failed to pay tribunal awards, quadruple tribunal fees to malicious or spiteful employers or employers guilty of gross oversight, and consider higher minimum wages for zero-hour workers. The government has also issued 4 new consultations on the enforcement of employment rights, agency workers, transparency in the UK labour market and employment status. In the meantime, various gig economy court cases continue to develop, including the Supreme Court appeal in the Pimlico Plumbers case in February, the Deliveroo case being subject to judicial review application, and the Uber case is listed to be in the Court of Appeal in November. Equal pay seems to dominate the headlines. In recent weeks, the attention has turned to Tesco, who are now facing a $4 billion equal pay claim from store staff, mainly female, who allege that they should be paid the same as the distribution centre workers, who are mainly male. Currently, there is a £3 per hour difference. Similar claims against Asda and Sainsbury's are already underway. Asda's case is the most advanced and is scheduled to be heard by the Court of Appeal in October. Now, the prospects of success look good for the claimants. Birmingham City Council has already been forced to pay £1 billion in fines after it was revealed that women employed as cooks, cleaners and carers received lower pay than men employed as bin collectors and road workers. Coastal UK has been ordered to pay penalties exceeding £400,000 for breaching trade union law by making offers directly to employees to bypass collective bargaining. The penalty for breaching is £3,907 per affected employee. There are provisions to allow direct offers to be made if the collective bargaining is broken down and the employer has a proper purpose for making direct offers. Clearly, getting this judgment call wrong can be costly. Cheapy law protects employees' rights in certain circumstances where there is a change in employer. In a recent case, Guevara acquired Blinkbox Music, BM, which employed 110 people. The business underperformed, and when its operations director left, a senior officer of Guevara started to manage BM under the direction of Guevara's chief executive. It subsequently decided to make 54 employees redundant and then transfer the assets and the remaining people to Guevara. BM went into administration and failed to pay the redundant employees. The Employment Appeal Tribunal, however, decided that the transfer date was the date that the Guevara senior officer took control of the business, and therefore at the time of redundancy the employees were employed by Guevara and not BML. Thank you for tuning in for this month's Commercial Bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in April with more of the month's key legal updates.